Welcome to Grant or Deny, a government contracts claim talk show that breaks down legal arguments and predicts, based on the record, whether the board will grant or deny the appeal. I am your host, Kelsi Pilcher, Counsel at Whiteford, Taylor and Preston's Government Contracts Group, and joining me today is Alyssa Stayinski, Attorney Advisor with the District of Columbia Contract Appeals Board. Thanks so much for joining me today.
Thanks so much for having me. I'm really excited to talk about the claims today.
Yeah, me too. We have 3 important decisions, so let's go ahead and dive in, and I can't wait to hear your predictions. So our first claim decision is ASBCA appeal of Tannic Construction Company Incorporated. In this case, the parties Tannic Construction and the Army Corps of Engineers resolved a previous contractual dispute regarding a deferring site condition, and this was done via a settlement and signed release. The release of claims language in the settlement included a provision allowing Tannic to pursue a claim for extraordinary contractual relief. When the government received the contractor's document entitled Certified Claim for Extraordinary Contractual Relief via FAR 50 and DFAR 250, the government moved for dismissal. If a contractor preserves its right to file a claim and does so for extraordinary contractual relief under these FAR provisions, will the board grant or deny the contractor's claim?
So my knee-jerk reaction is that the ASBCA is going to deny the contractor's claim for extraordinary contractual relief.
Okay.
Because at first glance, this feels like a pretty contractor-friendly fact pattern. As one, the settlement expressly preserved the contractor's right to pursue the claim.
Mm-hmm.
2, the contractor submitted a certified claim to the contracting officer. And 3, the contractor is alleging some pretty serious government misconduct.
Right.
But looking deeper, a red flag that jumps out to me is that the contractor expressly labeled its claim as a request for extraordinary relief under FAR Part 50 and DFAR's Part 250, which in essence are provisions that authorize federal agencies to grant discretionary relief to contractors in the interest of national defense. And that matters because the FAR explicitly states in relevant part that requests for relief under Public Law 8504 are not claims within the Contract Disputes Act of 1978. So even though the contractor submitted a certified claim to the contracting officer and the settlement reserved the contractor's ability to pursue this request, I think the important thing to remember here is that the preservation of a claim does not automatically create jurisdiction over a non-CDA claim. So at the end of the day, because the contractor's request for extraordinary contractual relief under Public Law 8504, then I think the board is just going to conclude that it simply lacks authority to review the claim in the first place.
Okay, well, that's fair, and you are correct. Because of those cited FAR regulations invoked Public Law 85804, and the claim did not reference or even seek relief pursuant to the CDA, the board doesn't have jurisdiction over the appeal. Any action or decision by an agency under that public law provision is actually within the exclusive jurisdiction of the executive branch, and it's not subject to judicial review. So with that being said, contractors really need to be careful of the language that they choose to include when they're preserving their rights to file a claim. So let's move on to our second appeal, which is Preston LLC. This is also before the ASBCA, and this one is against the Defense Logistics Agency. In this appeal, the parties contracted for web-based subscriptions, publications, and periodicals, and these were all referred to as canceled subscriptions when the government ended up issuing a stop work order. The contractor submitted an REA and converted that REA to a certified claim, seeking to recover its reasonably incurred direct and indirect costs. So far, so good. However, the claim did not mention factual allegations regarding the subscriptions or lost profits. When the government ended up denying the claim, the contractor filed a complaint with the following counts: 1, termination settlement; 2, constructive change; 3, equitable adjustment; and the 4th and final count was bad faith. The government subsequently filed a motion to dismiss counts 2 and 4, constructive change and bad faith. Will the board grant or deny the government's motion?
So my first impression is that the board is going to grant the government's motion to dismiss count 2 for constructive change and count 4 for bad faith.
Okay.
I think the key question here isn't whether the contractor could ultimately prove the merits of its claims, but rather is a question regarding whether the contractor even presented the claims to the CEO in the first place. Because as we know, under the Contract Disputes Act, the submission of a claim to the contracting officer is a jurisdictional prerequisite for an appeal to the board in order to give the contracting officer an opportunity to consider the claim before the board can review it.
Right.
So while the complaint can certainly expand on legal arguments, it can't introduce entirely new claims that are not based upon facts that are common or related to the facts raised by the contractor in its claim to the contracting officer. So looking at the facts of this case, the contractor's claim submitted to the CEO was pretty narrow. The contractor requested an equitable adjustment to recover direct and indirect costs incurred as the result of a stop work order. And further, the contractor went out of its way to state that its request includes, and I quote, no profit or unallowable cost elements. However, the complaint submitted to the board took on a much broader shape, where Count 2 introduced a new constructive change theory based on allegations that the subscriptions required separate subscription agreements and that the DLA prohibited the execution of those agreements, which are allegations that were not submitted in the claim to the contracting officer. And Count 4 seeks damages, including lost profits, based upon an alleged bad faith termination, even though, as I just discussed,
Right.
the contractor's claim to the CEO expressly stated that no profit was ever being requested. So my instinct is that the board's decision is going to focus on whether Counts 2 and 4 assert new claims. And once I see new factual allegations in Count 2 and a completely different category of damages in Count 4, I think the government has a pretty strong jurisdictional argument that the CEO never had the opportunity to consider those claims in the first place.
Well, your instinct is correct again. The board ended up dismissing counts 2 and 4. So count 2 was dismissed because, as Alyssa mentioned, it was based on entirely new facts. And count 4 was dismissed not necessarily because of new facts, but because the contractor asserted a new remedy in the bad faith allegation, which was lost profits. And those were actually expressly excluded from the claim. So similar to the first claim that we discussed, the board's jurisdictional requirements are strict. The board does not have jurisdiction over new claims that have not been first presented to the contracting officer, and that is indeed a prerequisite to the CDA for jurisdictional purposes. Alrighty, so are you ready to dive into the next, our last and final claim?
I'm ready, let's do it.
So the claims that we've discussed so far illustrate strict jurisdictional requirements that contractors must abide by when they're filing claims. So hopefully our final claim is going to give some reprieve to the contractor.
We'll see.
This one is Sonalil Construction Incorporated versus the Department of Interior before the Civilian Board of Contract Appeals. Here, the contractor was awarded a contract for the repair and replacement of building roofs in the Everglades National Park that were damaged during a hurricane. The appeal actually involves multiple claims. In its first claim, the contractor sought increased costs for supply chain performance delays during COVID. The government denied that claim. The contractor then submitted a second claim asserting bad faith, the breach of good faith and fair dealing, and changes. The government denied that second claim. The contractor then filed an appeal based on the contracting officer's second final decision, and the government moved to dismiss for lack of jurisdiction, arguing that the contractor failed to appeal the first final decision. It was the government's position that the second claim is barred because the relief sought is based on the same operative facts as the first claim. Will the board grant or deny the government's motion?
So unlike the last case, my guess is that the board is going to deny the government's motion to dismiss, because I think the contractor has asserted materially different facts and legal theories in its second claim, and therefore this is going to constitute a new claim under the CDA. Because the government's argument here is pretty straightforward. It argues that the contractor already submitted a claim seeking reimbursement for unforeseen COVID-related labor and material costs. The contracting officer denied that claim, and the contractor never appealed that decision. So therefore, because the first COFD is final and conclusive, the contractor can't simply file another claim seeking the same money just by reiterating an old claim. And that's generally a strong jurisdictional argument because under the Contract Disputes Act, a contractor can't avoid the 90-day appeal deadline simply by repackaging the same claim under a different legal theory. However, I think the board is going to focus its analysis on the operative facts and whether the second claim depends on the same factual allegations that were presented to the contracting officer in the first claim. So, as I previously mentioned, the first claim was really about the economic impact of COVID, as the contractor argued that the pandemic-related supply chain disruptions and unprecedented increase in labor and material costs made performance much more expensive than anticipated. But this second claim actually shifts the focus of the government's conduct. So instead of saying instead of saying COVID made the contract more expensive, the contractor alleges that government officials repeatedly promised that it would be compensated for those increased costs if it finished the project and relied on those promises when deciding to continue performance. So from those alleged promises, the contractor asserts bad faith contract administration, breach of duty of good faith and fair dealing, and constructive change. So in short, my instinct is that the board is going to conclude that these aren't just new legal theories attached to the same claim.
Right.
They're based on materially different set of operative facts, as the first claim turns on the market conditions caused by COVID, while the second claim turns on what the government allegedly said and did during contract performance. And if that's the case, then the second claim can stand on its own, and the contractor isn't trying to revive an untimely appeal of the first contracting officer's decision.
No, that's a great breakdown. And you are three for three. The contractor asserted materially different facts and materially different legal theories in that second claim, making jurisdiction proper, and therefore the board properly denied the government's motion. So regardless of the credibility of the contracting officers or the contractor's allegations, a motion to dismiss based on jurisdiction wasn't proper. And that means the contractor was finally able to walk away with a win in today's episode. So that wraps up episode 4 of Grant or Deny. We discussed 3 claims dealing with jurisdictional determinations that the government and contractors can definitely walk away with lessons learned.
And thank you so much to the Board of Contract Appeals Bar Association. If you're not already a member, we encourage you to join, and the membership information will be included in today's show notes.
And last but not least, thank you to Alyssa for joining me. This was a fun decision, a great episode. And so make sure you turn into the next episode of Grant or Deny.